All rise. Hear ye, hear ye, hear ye. The Court of Appeals of the State of Kansas is now in session. The Honorable Sarah E. Warner presiding.
Please be seated. Good morning, everyone. Welcome to the August 2023 oral arguments before the Kansas Court of Appeals. Before I call this morning's cases, I'd like to take a few minutes to introduce our distinguished panel of judges today. First, to my right, your left, Judge Catherine Gardner of Topeka. Judge Gardner joined the court in 2015 after several years in private practice and several years in the chambers of a federal judge. And to my left, your right, Judge J.C. Hurst, who has served on our court since 2021 and hails from Lawrence, joining us after a decorated career in private practice here in the Kansas City area. My name is Sarah Warner. I've served on this court since 2019, and I live in Lenexa and came from private practice in Lawrence. I will be presiding over today's oral arguments. We have 3 cases on this morning's argued docket. The first case is scheduled for 20 minutes of argument per side, and the other 2 cases are scheduled for 15 minutes of argument per side, including any rebuttal time requested by the appellant. This morning's arguments will be live streamed on the Court of Appeals YouTube page. And this also means that the video will be archived for public view. Because these proceedings are being archived, I am going to ask the attorney representing the appellant to take about 90 seconds at the beginning of the argument, that won't count against your time, just to summarize kind of the context of the case, what it's about, and how we got here. And that way people understand who are watching online what this case is about. In preparation for today's oral arguments, we have thoroughly reviewed the parties' briefs and the record on appeal, along with a legal memorandum that's been prepared by a research attorney. So we are very familiar with the facts of each case, and we encourage the parties, thus, given the short period of time, to dive directly into their legal arguments. At this time, I will call the first case on this morning's docket. This is from Johnson County, case number 125734, Austin Properties LLC appellant versus City of Shawnee appellee. Would the parties please state their appearances?
Good morning, Your Honors. Melissa Sherman with Spencer Fane for
Good morning.
Thank you. Ms. Sherman, you may begin.
May it please court. My name is Melissa Sherman. As I mentioned, I'm counsel for Austin Properties LLC, the plaintiff in the underlying appeal and litigation. This case, as Your Honor requested, is about the unfounded neighborhood bias against apartment development, influencing the decisions of elected representatives who ultimately chose to kowtow to a select group of neighboring property owners rather than fill their responsibilities as neutral arbitrators to make a reasoned, appropriate decision as required under Kansas law. Specifically, we are challenging the City of Shawnee's arbitrary and unreasonable failure to prove a preliminary development plan submitted by Austin Properties after that plan had been recommended and approved by the city's planning commission and professional planning staff, including the city's engineer. The evidence submitted to the city council supported and required approval of that plan. Unfortunately, the city council chose to take no action on that plan. It died by a vote of 4-4, ended in a tie. So rather than take the actions that were required under Kansas law to either approve the plan, specifically deny it, or send it back to the planning commission, it just ended, leaving my client without any use of its property.
Council, before you dive straight on into your argument, would you like to reserve any time for rebuttal?
I would, thank you, Your Honor. I would reserve 5 minutes.
5 minutes are granted.
Yeah,
You
thank
may
you.
continue.
Specifically, as I indicated, the evidence submitted to the City Council supported and required approval of the plan. Just briefly, and I'll discuss these more in detail, but the proposed development was in keeping with the city's future land use map and its comprehensive plan. Specifically, the future land use map designates the 29.2 acres of property owned by my client for development with a mixed use of high and medium density residential, which was entirely consistent with the plan that was submitted and proposed. Second, similar development plans had been previously approved by the City Council. We certainly acknowledge that those development plans were a bit different, but they had been approved. Third, a comprehensive traffic study had been prepared and submitted by a traffic engineer and found that the city street network could accommodate the proposed development and that it would not negatively affect the level of service of the surrounding streets and intersections. The city's traffic engineer specifically reviewed and concurred with that study. Fourth, the city confirmed with the superintendent of the DeSoto School District that the proposed development would not negatively affect the area schools and that they had been planned for growth and specifically could accommodate it. And fifth, the development was carefully designed to be an upscale luxury complex rather than the terrible apartment building that all of the neighboring property owners made it out to be, and was specifically designed to have a buffer that would allow for a transition between the existing single-family homes and this proposed development.
So it sounds like you're arguing that if you have enough evidence, then the city has no discretion to deny it.
It's a fair question, Your Honor. And I would say, yes, depending on the facts. If there is so much evidence and there's really nothing to support the city's decision to deny, then yes, I would agree with you. I think it would be fair for debate if there was competent evidence in the record that supported a denial, such as a competing opinion of a traffic engineer, someone else from the school district who might come in and say, with reason supported evidence, that there is an issue with schools.
Well, isn't one of the issues that is considered the impact of the neighboring communities?
Certainly, Your Honor, that is absolutely considered. And it was considered here. There was evidence that was presented that there would be no impact on the surrounding community. And what we heard from the neighboring property owners was just general sort of concern about traffic and sort of self-serving, biased opinions, lay opinions, that there were traffic issues, that we're going to see overcrowding. There was not any sort of competent evidence that suggested that those opinions were founded. And it was contrary to the expert evidence and testimony that was presented to the City Council.
Can you point us to the statute or case that you think supports your proposition that with appropriate evidence, the city is required? You can't just willy-nilly say no.
Well, I will. We did cite and rely on Sechrest, the Sechrest case, Your Honors, and we certainly acknowledge it was an unpublished opinion. Without question, it should be given the attention that it's due as an unpublished opinion, but we do think that it is compelling and supports the city's position in this case. And specifically in Sechrest, it does talk about the City Council being required to be neutral arbiters. It does talk about the council being required to make reasoned decisions based on the evidence and not just simply rely on the unfounded lay opinions of neighbors. It doesn't go so far. I would agree that the city is required to take action, but it does speak in terms of reasonableness and whether.
But isn't it possible for the City Council in this case to have heard the expert's position and disagreed with it?
I don't believe so, respectfully, Your Honor. The council members were not qualified to quote unquote disagree with it, nor
They're the empowered decision makers, correct?
That's true, but they've got to come with their, they've got to base those decisions on competent evidence, the evidence that was presented. They don't have the ability to simply follow their gut or listen to the neighboring property owners. And we've seen that both in the factors that are set forth in Golden and the decision as it was applied in Sechrest. So yes, while it is true that they are the decision makers, those decisions should still be grounded in appropriate evidence, founded in reason. And here, we did not have any reasons stated for a number of the no votes against this application.
In the golden factors, do you have a contention about which golden factor that it was relied on for the denial?
No, Your Honor. That's an excellent question. There really was no, as I said, reasons given by 3 of the 4 council members for their denial. And when pressed, the prior council members in a previous meeting, 2 of them had stated sort of generalized concerns about traffic and so echoed the issues that they were hearing from neighboring property owners. But contemporaneous with their vote, they did not give voice to their specific reasons for the denial. One council member didn't say a thing during the entire hearing, both the first council meeting and the second council meeting. So we just simply don't know what was going on at the time that they made their decision. We can presume, though, that they, consistent with the statements 2 of the council members had made, that they were just simply parroting what they heard from the neighboring property owners. One of the council members specifically made a statement, and I'm not going to quote it verbatim, but something along the lines of, the neighboring property owners were here first. I think that should count for something, effectively saying that if they're here first and they really don't want this development, then we should defer to what they, how they feel and what they think. And that same sentiment was echoed by one of the other council members.
Before you run out of time, do you guys have anything else? I want to switch to the statutory argument.
Sure.
The argument regarding the failure to comply with subsection B.
Absolutely. I can. And specifically, you're talking about KSA 12-756. Okay, very good, Your Honor. As we argued in our brief, the statute is, we believe, clear. The council is required to take 3 actions. Specifically, I've got it here in front of me. The governing body, when there's been a recommendation by the Planning Commission, which was the case here, must approve such recommendation by adoption of the same by ordinance. 2, override the Planning Commission's recommendation by a 2/3 majority vote. And 3, return the same to the Planning Commission for further consideration, together with a statement specifying the basis for the governing body's failure. And those options do make sense. If you've got a property owner like my client, who now owns about 30 acres of property that is sitting vacant, he can't do anything with it. And it's been vacant, I should say, for 20 plus years. And if this application is not approved, there's simply no viable way to develop this property. So it's going to continue to sit. So it does make sense. The council should be required to say what it means. I'm going to approve it, I'm going to deny it, or I'm going to send it back with specific directions for what we see wrong, what needs to be addressed. And none of those things happened here.
Isn't 756 for original zoning?
Your Honor,
Should it apply here instead of 757?
Well, I think we do. This is a case of a proposed development plan. So this was the first time that this specific plan had been considered. So we do think that 12.
Sent up for this plan before, right?
Yes, similar plans, not this particular plan. And we do think, and your question is a good one, Your Honor. We do think that 12-757 applies to something else entirely. I mean, specifically, if you look at the statute, it speaks to changes or revisions and boundaries or regulations in this by zoning amendment. That's not what we have here. What we do have here is what is discussed in 12-756. Establishing any zone or district or regulating or restricting the use of buildings or land.
Council, I'm looking at 755, which says that a governing body can adopt ordinances having to do with a planned unit development. And here the city of Shawnee has adopted an ordinance that talks about the procedure for considering a planned unit development. And that procedure that the city has adopted parrots 757.
757 is very similar with 756.
In that case, I want to take a look at 757 F1, and I'd like for you to explain to me how that procedure does not apply here. That procedure, which is triggered upon a protest decision, which is what we have here.
Sure, I understand your question, Your Honor. Again, we go back to the specific starting point of those statutes. For 12-757, it speaks to boundaries or regulations contained in zoning regulations by amendment. Here we don't.
But I'm not talking about 757 itself. I'm talking about the language which was incorporated into the City of Shawnee's ordinance covering planned unit development.
Right. And in our position, Your Honor, is that's simply not permitted under the statute. As we've argued in our briefing, 757 is narrow and does relate to more specific things.
But I'm not talking about 757. I'm talking about the ordinance. So why is the ordinance improper? If 755 allows a city to adopt an ordinance that sets forth a process.
It does indeed, Your Honor, but 757 only speaks to allowing protest petitions for certain matters. And our position is that the city does not have authority to expand that statutory review or the ability for property owners to file protest petitions just by amending their own code. That's the position.
And what is your authority for that?
I mean, we've cited some general Kansas law to support the idea that the city only has specific authority to approve its municipal code, that it must follow the statutes as written, does not have the ability to expand that.
So in light of that, let's just presume that the code is, just work with me and presume that the code is effective. If that's the case, then again, why don't we follow that protest petition process here, which appears to be what the city says that it did?
If we're assuming that it does apply, I don't think I could argue with you. I mean, because we would be assuming that it applies. Our position, of course, is that it doesn't. And we do think for good reason. As we've already discussed, there have been no less than 3 prior development plans that have been approved for this property. The property has long been zoned for this exact use, long been planned for this exact use.
I'm going to stop you because I want to be clear. Let's assume 757 applies. 757D would apply if there were no protests.
Correct.
And 757F has a protest position. How do those then work together? Or do they not? Is it your position? Are you conceding that if we think 757 applies, that then if there is a protest, the city is not required to take any of the other actions under D?
I do think that is the law, Your Honor. As much as I would like to argue otherwise, I do think that there is Kansas case law that would indicate that if there is a protest petition, that sort of overrides the Planning Commission's recommendation and requires something more.
So it would require a 3/4 vote to approve.
Correct.
And then if there is a protest position and there is not a 3/4 vote to approve, your contention then is that 757D2, there's nothing for them to do there under the other provisions of D.
And we're presuming that it does apply in your hypo. Yes, I think that's right. I mean, I do think that's the way the Zimmerman, I believe it's Zimmerman court held, that if there is a protest petition, that sort of overrides the process that's set forth in the statute. Again,
not just the voting requirement.
Yes, that's correct. Again, as much as I would like to argue differently, I think I've got to acknowledge current Kansas law. I want to be intellectually honest here. But again, our position is it shouldn't apply. And again, for good reason. Let's just say a planned unit development was approved in 2023, no protest petition, everything's fine. A couple months later, we've got another planned unit development that's now been proposed. Maybe the property's changed hands in the meantime. We've got just a few months that have passed. Maybe we've got a cantankerous neighbor that's moved in next door, but now all of a sudden we've got pretty much the same circumstances. And now we're allowing another protest petition to affect the process and development of this property. Our position is that protest petitions should be limited to things such as original changes in zoning, which is not at issue here. What is at issue here is how specifically this property should be developed. And again, the way this plan has been proposed, it's quite consistent with what the intended use of this property is. This property borders a highway. What else are we going to have here? Apartments make perfect sense. And the land use specific plan specifically says high density use toward the highway, which again makes sense, medium density use next to the single family. And that's precisely what was proposed. And I don't want to move from the statutory argument if you aren't through with your questioning, but I do want to go back to.
Council, we are at 15 minutes.
Okay.
But you're free to continue, but it will start going into your.
No, that's fine. I'll reserve my time. Thank you, Your Honors.
Council, you have 20 minutes.
Thank you, Your Honor, and may it please the court. Andrew Holder on behalf of the city of Shawnee. At the court's direction, I'd like to just dive right into the legal issues here. And I think it may make sense in light of where we are to start with the procedural issues and then get into the substantive issues. So as I understand the appellant's position, there are really two procedural challenges here. The first one is, does the city have statutory authority to enact a zoning ordinance that would create a protest petition system, essentially, in the first instance? And I think the court has already hit the nail on the head in terms of the statutory authority for that, which is KSA 12-755A, which gives the city broad discretion to enact zoning ordinances, which it specifically include for planned use developments.
Are there limitations on that authority? I'm looking at 757. 757 has to do with a specific thing, which is, if there is a revision to a zoning plan, that's different than a planned unit development. Is there a limitation on what the city can do there?
Absolutely, there is. The city's limitation is that it can't enact zoning ordinances that directly conflict with the statutes that provide the procedures like 12-757. So for instance, if the city wanted to enact a zoning ordinance that said, you can have protest petitions for planned use developments, but it only requires 10% of abutting neighborhood owners to trigger a protest petition, perhaps we could have an argument about whether that would conflict. If they just wanted to say you can do a planned use development and we'll just decide it and nobody gets to have a public hearing about it, that would conflict with it. So to the extent that there's a conflict, we would have a problem. But as the court noted earlier, there is no conflict here because the city's zoning ordinances here directly match 12-757F, at least as it relates to the protest petition. So as it relates to the question of, does the city have statutory authority to enact the zoning regulations it did, I would point to both 12-755 generally and the fact that it mirrors 12-757F.
Except that F is for something different than a PUD.
I don't think I agree with that.
Okay.
When you talk about F and the way that courts have historically applied it, I think 12-757 is where we shift from general zoning regulations, such as, for example, if the city said we're going to establish a zoning district here, and this is going to be the residential district, and we're establishing that for the first time. That's where I think we get into 12-756. When we turn and focus on revisions to the general zoning regulations the city has entered, that's where 12-757 applies. That's why we've got, and there are numerous cases that have interpreted it this way. When somebody applies for a conditional use permit or a special use permit.
How is this a change to the zone?
Well, when we take the general zoning code and we make a specific change to a specific property, that's when it becomes a change, just like a conditional use permit or a special use permit. And you can also point to the city's zoning code for that, which specifically says that each time an application for a development plan is entered, the city treats that as rezoning.
Of course, the PUD wouldn't actually change any of the zoning, right? I mean, it would still be zoned as whatever it is.
DMR is
That's
the
right.
acronym. I'm not
Yeah.
sure I can get all the real words out right now. But
Right.
yes, I agree with you that conceptually it's a little odd because we're going from PUDMR to PUDMR, but That's specifically what the city zoning code provides. And the reason it does that is because each PUD is put into a district, just a PUDD, which is another mouthful.
But it's also not a change, though. I mean, you understand the distinction I'm sort of having trouble with. I understand that the city made this rule. Hey, we're going to pretend that a PUD is rezoning something, but it doesn't act.
In the sense that it just goes from PUDMR to PUDMR. I totally agree with you about that. Where the specific change happens here is the fact that the development plan that was being applied for here is substantially different than the previous one that was approved. And that's where the real change happens here. If it had been the exact same, or I think the specific verbiage in the city code is substantial compliance with the previous one, we wouldn't have this situation. That wouldn't be triggered. Why this happened is because the application here was substantially different than what had previously been approved, which is why we have public hearings, because it's a different change and the public gets to hear why we're going to approve it or deny it. So circling back to the statute, I think whether we're talking about the city code or we're talking about 757F, we're really talking about the same general procedure here. And so I think that the next relevant question here, and I should back up and say, the record on appeal makes clear that the protest petition was valid. There's never been a change or a challenge to the fact that the correct number of signatures were obtained or that the protest petition was timely filed. So as far as that goes, the record is clear, I think. So the question is when and it's also undisputed that a 3/4 supermajority was not obtained here. So the question I think becomes under either the city code or the statute, what is required if that happens? And I think the key verbiage here, if you look at the way the two statutes or the two subsections work, is if you look at 12-757D, the preamble to the actual meat of the language is, except as provided in subsection D, and unless otherwise provided by this act, which I think is the key signal that when a different subsection that's more applicable applies, the subsection D does not control here. So, and it's our position that we're just looking at the procedures under subsection F. And under subsection F, the decision is pretty binary. You either obtain a 3/4 supermajority vote necessary to pass the resolution, or you don't. And if you don't,
Then what?
if you don't, and then there are a couple different options on the table.
What are they in the statute?
And they're not in the statute because all the statute says is, I'm sorry?
Weird, because there are other options in D.
That's exactly right. And so I think that's notable here because when we're looking at F, it's either it passes with a 3/4 majority or it doesn't.
Why does that make sense, though, if you have such public interest in it, that you have a petition filed, protest petition filed? Why can you just be one and done instead of having to send it back to the planning commission?
Well, I think that that's the entire point of requiring the supermajority is that it either has the collective support of 3/4, in which case, it's okay to ignore the fact that the protest petition has been filed, or it doesn't. And if it doesn't, I think that's the entire intent behind requiring the supermajority in the first place, is to make it more difficult to pass one of these when there's that much public opposition to
So
it.
how would following the procedures in D then change that? It would still be difficult to pass. It always would need 3/4.
Well, the way that subsection D has been interpreted, and if you look at the language in there, that's where you get into the fact that, let's say you've got a situation where you've got a simple majority that doesn't agree with the planning commission, right? Your options are really twofold at that point. You don't have the votes necessary to outright override the planning commission. So you can, your option is essentially kick it back down to the planning commission for another recommendation and specifications about what the problems are.
Sure, but why wouldn't you do that even if you can't reach a 3/4 majority? I mean, maybe you can't reach a 3/4 majority because there's a weird traffic situation and you need a stop sign or whatever. So then you kick it back and then the planning commission can fix that. And then lo and behold, there isn't a problem anymore, or new petitions for protests are filed and you still have to get 3/4. I mean, why would we read these things to not work together? When I look at statutory interpretation, it seems odd that I would read these to be mutually exclusive when they read together very well.
Well, I think that in a case like this, I think the option if you don't, let's say a protest petition has been filed, I think that the city had the option because the motion that was made was I moved to adopt this and that didn't get it. There could have been a follow-up motion by the city to remand it to address specific issues. I don't think I think F, the only thing F precludes is adopting it. It doesn't say that they can't do it. It's silent on that. Right. And
I don't want to take up all of your time because I do want you to address the actual substance.
yeah, and I'm happy to shift gears to that. So when we're talking about the substance that we're talking about the golden factors, and I think that it's important to begin with the starting point, which is that there's a presumption that the city has acted reasonably here. What we have in this case, it's certainly true that there's not a written decision that spells out a point-by-point analysis of each voting member's decision under each golden factor. That's absolutely true. The courts have also told us that that's not required in order for a decision to be reasonable. What we're looking at here is, can we ascertain from the record that was before the city council why they did what they did? And when we look at it here, we've got a record from a hearing on December the 9th, where there's some discussion from various council members about problems that they had or concerns that they had. And then we've got the minutes from the 23rd. After the fact, in this case, we also had deposition testimony that I think supplements that decision.
What statements were made by them at the time to support their ruling?
I think the primary focus, and we're talking about 4 different people, so there's obviously not one statements from each of those, but the primary focus was really on 2 things there, and that was density and height. And when we talk about density, we're really talking about objective facts here. I mean, the density is a simple calculation that anybody can do. We're talking about how many units there are over how many acres are. So,
but density may cause a problem, but the number of people in one place, you assume it might cause problems like traffic or crime or not enough room in the schools. But density itself isn't the problem. It's a cause of a problem.
Density itself.
And here, didn't you have evidence that the potential causes of the problem weren't going to be problems?
I think that as it relates to density, I think that there was evidence that schools may not be a problem. There was also concerns from people that they might be. And I think we're talking about weighing the evidence there. And specifically as it relates to school, I think it's important to note that one of the issues here was the information we had about the schools was a secondhand report from staff that said, I spoke to somebody at the schools and they said it's not going to be a problem, more or less. And you had at least one council person that said, I understand that. I don't have any reason to question you about it, but that's not very strong evidence. I can't place a lot of weight on that.
Is there evidence that it would be a problem? I mean, these are apartments that would house many children at this price point? This is what we're thinking. There are going to be apartments where lots of children will be housed. So what was the evidence that there would be a problem?
I think the evidence that there would be a problem in schools to begin with is it's undisputed that there would be a lot more population. So I think there was an assumption that more population brings more children.
That's an assumption.
Sure, but I think it's a reasonable one to make.
Really?
Yeah, I think. Huh?
Tell me why.
I'm
not familiar with lots of apartment complexes that have no children.
And it may be the case. I don't think that we at this point, obviously it hadn't been built, so we can't go tenant by tenant and tell you. But I think that the operative assumption from everyone from staff up was that there would be an influx of people and more people.
So how many kids could the schools handle an influx of?
We don't know the answer to that because we didn't have information from the schools about that, which I think was the concern that the council member addressed to begin with.
So it would have been helpful maybe to go back then to the planning commission and have them check into that.
I think ultimately that's their decision to make based on the evidence that they have. That's one thing they certainly could have done, but the fact that they didn't and they made a decision based on the evidence they had is certainly within their discretion as well. I think what we're talking about is weighing the evidence that was before them when the vote was called.
Do you agree then that the city had the discretion to weigh the concerns that were voiced at the public hearing more heavily than those of what your opposing counsel calls the expert reports?
I think that the city council had the authority to determine the amount of appropriate weight to place in the expert reports. I think that they had the ability to listen to what people that were in the school districts had to say about that and determine how to weigh those two competing things, certainly. Ultimately, I think as it relates to schools specifically, that's the concern, is that there was a secondhand report from staff on the one hand, and there were people who said, my children are in these schools, here are the problems that I'm having on the other. And so that's ultimately an issue that they have to weigh.
Council, you indicated that there's a presumption of reasonableness with regard to the city's decision here. And that's true. That's what the case law says. But the case law also says that there has to be some articulation of the rationale, even if it's not in a written articulation. There has to be some articulation. And I'm looking at this record and I'm trying to figure out if this is enough, right? Is this enough? Because if so, then we really don't need an articulation at all.
I think that it is enough. We talked about the two key concerns here. They were density, and the one that goes along with that is the height of this in comparison to mature residential homes in the area. And I think those go part and parcel with each other, because we were talking about 3 projects that had been approved with this before that had essentially the same or slightly less units, but kind of in the same ballpark, but in a much bigger space. And then all of a sudden we've got the same here in a smaller space. And when you combine that with the fact, I think that goes part and parcel with the concerns about height, which is we're adding a lot of people, it's going to be really big. And when we're comparing that to the single family residential homes that have been here a long time, there may be a concern about how it would fit with the character of the neighborhood. I think those all go part and parcel with each other. And when you look at the record that we do have, I think that density and height are 2 of the issues that are discussed sufficiently in the record. And I think that's what the district court found when it was ultimately able to rule on this. And even to the extent there was ambiguity in the record, the resolution for resolving that ambiguity would be to remand it for further development of the record. There's case law that's cited in my brief that talks about that concept as well. If the question is we can't decide how or why the city council did what they did, that's the resolution for that.
I think that you can understand our conundrum here. I mean, we're a court of review. We're looking for something to review. And it's hard to find it given this record.
I think that it certainly would be more helpful to have a written decision after the fact, but ultimately I do think that the comments that are made both at the December 9th meeting and at the December 23rd meeting are adequate to identify the concerns that the individuals that voted no had here. And that's ultimately what the district court held. The other issue that we've talked about is traffic. And I think that there's a difference to some degree between saying, I'm worried that bringing more people will bring more traffic and articulating specific concerns. And there's at least one council member that expressed concerns about traffic and articulated specific concerns that she saw based on her own firsthand experience living in the area in specific locations and concerns that she had. So I think when we talk about trying to weigh the evidence again, I think that it would be impossible for somebody not to take their own firsthand experience into account when they're trying to determine whether there's going to be traffic concerns or not. The other thing I think that's worth mentioning is when we talk about traffic concerns, the other issue here is not so much can the roads have it, but the concept of adding additional through traffic in the Woodsonia area, which wouldn't have been there before. So it's, can it handle it? Yes, but is there going to be an increase in traffic where there was none in a residential area? Also, I think the answer is yes. So when you focus on those 4 issues, which I think are adequately supported by the record, and we weigh that under the deferential standard that's given to the city as the decision maker here, I think you land in the same place that the district court landed here, which is that reasonable minds could differ here about whether this was a decision that should be made the way it was or whether it could go the other way. And when reasonable minds can differ and the tie goes to the city as the decision maker, the decision has to be upheld as reasonable. And that's what I'm asking for here, Your Honors.
Yeah.
Barring any other questions, I will rest. Thank you.
Thank you. Council, you have 5 minutes.
Thank you. May it please the court. There was a comment about the report about the impact on schools being sort of an offhand comment made by a staff member. I do want to be clear that the mayor herself indicated that she had discussed this with the superintendent. That's my recollection. And she specifically said and this is cited in our brief, again, the superintendent has said that they have more than enough room at the schools. They actually support this project. They think this project would be good. And I think what is also telling is that she went on to sort of make this impassioned plea to the council members to be reasonable. She said, we have to make our decisions based on the facts that are presented to us, like a judge does. We cannot take emotion or feeling or any of that when we are making our decision. They have to be based on fact. So I think that is what Austin's attorney was referring to when he meant that the decision we made, I have to potentially, if it doesn't pass, stand before a judge and explain why we did not think it was a good fit for the city. And when all of our studies and all of our plans and all of our information tells us it is, how do we stand before them and say that it's not? That is precisely what we have here. Council suggested that it would be appropriate for council members to rely on their firsthand experience. And while that may be true, if it is just normal lay experience, that it is appropriate for lay people to testify to. You know, I don't know, what is a normal stopping distance? Things like that. But what we have here is something more that you cannot just rely on lay firsthand experience. And might I add, as I started this argument with, biased firsthand experience. There is a clear bias in this case against apartments. Like it's going to be terrible for the neighborhood if we have apartments and all of the things that go along with that. We're going to have crime and riffraff and all of these people who aren't homeowners.
Would you agree that hiring someone to do a traffic study is focusing on the wear and tear on the streets, the traffic flow, sufficient directional signs, that type of thing, but the homeowners have a different concern about an increase in traffic in their front yard because they have children playing there?
I understand your question, but I do think the traffic study generally addressed that. I think there was also testimony in the record that the traffic engineer and others, including I think the mayor, had gone out and studied that to see what the traffic patterns were actually like and that the concerns were unfounded.
Do you think, though, that someone who buys a house in a particular type of neighborhood with a particular type of feel has some right to try to keep their neighborhood feeling that same way?
I think that they may feel that way, and I do understand that feeling. But I think that they do that at their peril. If they move in next to 30 acres of undeveloped ground, we see that all the time. Someone moves next to 30 acres of undeveloped ground that's slated for commercial. And then all of a sudden they're upset when a Walmart is going in. Well, you know, when you purchase your property that this ground is there. That
This has been previously approved for, I apologize for cutting you off,
no, that's okay.
for apartment complexes.
Let me look at you have a little cheat sheet here on what had been previously approved. But the short answer to your question is yes, multifamily development had been previously approved. And it's the plan sort of waffled between townhomes and cottages and multifamily development. And I would not argue to you that the apartments that were planned were not different than what was before. I think that's true. But we heard about density being a concern. I think your honors were appropriately skeptical of that, because the reality is the density under the current plan with the reduced acreage really is unchanged from the plans that had been approved before. Remember, we had significantly more acreage with those prior plans. So we're going to have the same impact on schools, impact on the streets. And specifically with regard to the first plan, far more impact because it included a swath of commercial development, which this plan does not. So the suggestion that density is somehow a problem here is really just not accurate. The same thing is true for height. We have an argument that the height of these buildings will impinge on the character of the neighborhood.
It seems like the city, though, is saying they don't have to actually prove that those are going to be problems. They just have to be sort of concerned.
We disagree, and we believe that there is significant case law to suggest that that's not enough. Court talks about it in Golden. Court talks about it again in Sechrist, that you cannot have these amorphous concerns about traffic or other things, the boogeyman hiding in the corner. That is not enough. And again, the court has said we've got to look at this as neutral arbiters of the facts and the evidence. We cannot just defer to these sort of unfounded concerns. And specifically,
Council, I'm going to stop you because we've come to the end of your time, but I want to make sure that my colleagues
Sure.
have other questions. Do you have other questions?
No.
No? No? All right, but then take 30 seconds and wrap up.
Oh, mostly I just wanted to say, Your Honor, that it has been such a pleasure and a delight to argue to a panel of female judges. I love it. It's been an honor. Thank you for your time.
Thank you very much. The court will take this matter under advisement. I want to thank the council for your time arguing this morning and for your thoughtful written briefs. We'll endeavor to issue a written decision soon. Thank you. All right. This next case on this morning's docket is an appeal from the Workers' Compensation Appeal Board. Case number 125592, William Weaver, appellant and cross appellee versus Unified Government of Wyandotte County, appellee and cross appellant. Will the parties please state their appearances?
Your Honor, the appellant, William Weaver, appears by and through counsel Keith Mark and Anna Mark of Mark and Burkhead.
Thank you.
Good morning. May it please the court, Denise Tomasic appears on behalf of the Unified Government.
Thank you. Mr. Mark, will you be arguing today?
I will, Your Honor.
All right. Would you like any time for rebuttal?
I would, if it may please the court, I would like to reserve 7 minutes of my time to take up the cross appeal.
7 minutes. So we'll divide your time 8 minutes and 7 minutes.
Thank you.
Mr. Mark, as I indicated at the beginning of today's session, I would appreciate it if you would take about 90 seconds to explain the facts of the case, just so there can be a record on our YouTube channel.
Yes.
Thank you. And then once that 90 seconds is over, we'll go on ahead and get started.
May it please the court again, I'm Keith Mark, and I represent Mr. William Weaver, the appellant in this matter. And this is a workers' compensation case, and this is on the heels of a few other workers' compensation cases on the same general issue that has made its way to the court regarding the AMA Guide 6th edition. Back in 2015, the legislature passed a law that said that all permanent impairment after 2015 would be decided by the AMA Guide 6th edition. The way that was initially handled down at the trial court level was that the judges were strictly looking at the 6th edition and nothing else. Obviously, those of us on the claimants bar thought that that violated some constitutional issues. I brought the first case up here that this court decided Pardo versus UPS, and you concluded that the 6th edition was unconstitutional as it applied to Pardo, because it violated his due process right to a substantive adequate remedy for giving up his tort right. A very famous case came to the Supreme Court, Johnson versus US Foods, and in that case, the Supreme Court decided that it would be unconstitutional if you just used the 6th edition, but using a totality reading of the statute, it only made sense because functional impairment is defined as using competent medical evidence, that we had to apply competent medical evidence as well. You would think that would have decided the case, this issue, but it didn't. Because that case involved body as a whole injuries, when it got back down into practice, the judges were saying, well, that was only a body as a whole case, so we're not going to use competent medical evidence in scheduled injuries. I thought that would have been decided when this court decided Garcia, because Garcia gave an example of the best way to figure functional impairment. And although that was a body as a whole case, this court used the example of a scheduled injury. But here we are. And so that is the issue that's framed today is, do we use competent medical evidence in deciding scheduled injuries, just like Johnson said we should use always? Or I guess the converse is the people that only have scheduled injuries have their impairment decided by less than competent evidence. So that frames the issue. May it please the court, I would like to reserve, as we spoke, 7 minutes of my time for rebuttal. As I indicated, this case involves an issue of statutory interpretation. The issue is the calculation of functional impairment under KSA 44510 DB23 to be determined by using the 6th edition solely, or is it to be determined by using the 6th edition as a standard starting point for the more important and decisive competent medical evidence? The appellant maintains that the latter reading is the correct one. And from reading the briefs, it appears that the appellee agrees with that as well. Of the two possible interpretations, the one that includes all competent medical evidence is clearly consistent with the Kansas Constitution, and the one that exclusively uses the 6th edition is likely unconstitutional. If this court adopts the constitutionally questionable interpretation, then appellant maintains that the statute is unconstitutional for multiple reasons set forth in our brief. However, if the court adopts the more logical reading of the statute, then the constitutional challenges presented herein need not be addressed. Let's start by looking at the statute in question, KSA 44510 DB23. And that's a part of the Kansas Workers' Compensation Act. And in fact, it is the statute that decides how injured workers, like the appellant, that have had a scheduled injury are compensated for their permanent impairment. That statute reads in part, the loss of or the loss of use of a scheduled member shall be based upon permanent impairment of function to the scheduled member. The key phrase there is permanent impairment. And that is also referred to in the Kansas Workers' Compensation Act as functional impairment. Now, functional impairment itself is defined at KSA 44508U. And that statute reads in part, functional impairment means the extent expressed as a percentage of the loss of a portion of the total physiological capabilities of the human body, as established by competent medical evidence. Thus, by definition, functional impairment necessarily incorporates competent medical evidence. The appellant contends that both statutes must be read in conjunction with one another, and by definition, functional impairment must always be determined by using competent medical evidence.
Is there anything to the fact that perhaps by scheduling injuries that incorporates some competent medical evidence when they say you have a scheduled injury and this is what your impairment is, as opposed to injuries to the body, the whole, where it's much harder to determine and you need medical testimony?
All impairments need medical testimony. And you hear the argument that possibly body as a whole injuries, if I understand your question, may be more significant. But honestly, Your Honor, I don't believe that a back strain is more significant than someone that has their arm cut off at the elbow. And
Counsel, I don't think that we're saying that it's more significant. Just saying that there's been a legislative determination, perhaps, as to the nature of an injury. So the evidence that's presented is different from the evidence that might be presented with regard to the body as a whole.
yeah, but I just disagree with you, right? Because if they're going to mandate the 6th edition to serve as a standing starting point, that is all based on medical evidence, correct? And so as the appellee agrees on this issue, if you look at KSA 44508U, it's the definition of functional impairment. And in the definition, it says competent medical evidence. So it would make no sense that we would determine a level of functional impairment and not utilize the statute that defines functional impairment. And so when you look at some of the critical issues that are involved, in fact, I'll give you 4 independent reasons why this reading of the statute is more correct. Look no further than the case law. In the recent Supreme Court case, Johnson versus U.S. Foods, and then this court's decision in Garcia versus Tyson Fresh Meats, the Supreme Court stated so very plainly, the key fact the Johnson court said is percentage of functional impairment must always be proved by competent medical evidence. More recently, this court in Garcia discussed the issue further, and this court stated a process which ensures that all relevant evidence and information is represented in the impairment rating equation safeguards the injured worker's right to receive a viable and sufficient substitute remedy for relinquishment of their ability to pursue a tort-based claim. And second, this reading is supported by the rule of constitutional avoidance. A reading of a statute that's on solid constitutional ground must always be favored over a reading that likely renders the statute unconstitutional. To read this statute to exclude competent medical evidence would violate appellant's due process right to have an adequate substitute remedy for injuries to his person, and that would violate Section 18 of the Kansas Bill of Rights.
Counsel, I think that maybe we're kind of talking for the sake of talking on this, since there's some agreement, but I'm looking at the board's decision, and I'm looking at 44.510 DB 23, and given the reference to competent medical evidence within that statute, I'm having a difficult time understanding why the board did what it did here. Could you help me understand that?
I wish I had a good answer to that. I would state that there are some extremely bright minds that practice in the area of workers' compensation. How the board and the judges continue to rule that way in light of decisions that have been made at the Supreme Court level and at this court level, I really don't have a good answer for that. But I would like to point out something that this panel mentioned in the earlier argument about reading a statute congruent with all other portions of the statute to make it consistent with one another. And to use KSA 44.510D to determine the level of functional impairment, but to ignore the statute that defines it, that would violate the interpretive canon that this panel mentioned in the earlier case. And fourth, it's quite possibly that the no reference to the specific medical evidence in this statute may very well be regarded as a Scrivener's error. And there are many of those in this court. When workers' compensation is amended, they do it piecemeal. And you need to look no further than KSA 44.508U that defines functional impairment. When the revisor was going through the statute, they meant to change all the fourths to six, but they missed that one as well. So it's easily interpreted, it could be easily be interpreted that the omission of competent medical evidence was a Scrivener's error, or you could simply say that the inclusion of it in the body as a whole statute was overkill because it was already present in the definition.
Counsel, let's assume we agree with you. I would like to know what competent medical evidence there was that was relied on here by the physician. I'm presuming it's Dr. Karabata's 8%, which seems to be based solely on the 6th edition.
You are 100% correct. 3 physicians testified in this case, a physician on behalf of the employee, one on behalf of the employer, and then the court's doctor. And only one of those doctors took into consideration competent medical evidence, and that was ours. That was Dr. Popa. Dr. Karabata, he only looked at the 6th edition. He made some references to the 4th edition. But more pointed is the administrative law judge himself stated in his decision when he arrived at his level of permanent impairment, he did not look beyond the 6th edition. He specifically said that he did not look at competent medical evidence. And so although the appellee and the appellant agree on the main issue in this case, where we do disagree is whether the award should be left as it is, which goes to your recent question, or should it be remanded back to the administrative law judge? So after conceding the main issue on appeal, the appellee goes on to talk about how somehow, even though the judge didn't follow the statute the way we agree he should have, he just came up with the right number. But appellant would suggest that there's no way that we know that as we sit here today. Until the administrative law judge goes back and completes the correct analysis using the statute as it should be, starting with the AMA Guide 6th edition, and then applying all relevant competent medical evidence, which could be anything in the record that would be probative to determine what level of permanent impairment this litigant has. That's the only way we're going to know. So because the statute was incorrectly applied, we can't know what the correct impairment rating is until the ALJ does what we suggest. So therefore, appellant requests that the case be remanded back to the administrative law judge for factual findings and a recalculation of the award consistent with the holding of this court.
Other questions from the panel? All right. You've reserved 7 minutes for rebuttals. Counsel, you have 15 minutes, and I take it you're going to address both your appeal, your appellee's position and your cross appeal in this argument. Is that
I will now.
Thank you.
Good morning. Thank you for your consideration. Again, my name is Denise Tomasic, and I represent the Unified Government, who is the appellee cross appellant. Counsel indicated that we had conceded the primary issue on the appeal. I find that to be a harsh way of looking at this. I agree that the Johnson analysis should be applied. It only makes sense. But the focus of the case as set forth in the Johnson case, I think should be a little different. The statutes, both for the body as a whole injuries and for scheduled injuries, discuss either basing an impairment rating on the 6th edition of the guides, which is the body as a whole criteria, or using the 6th edition of the guides for scheduled injuries. And then we have a separate statute that talks about functional impairment and having to use competent medical evidence to arrive at a decision on functional impairment. And so I think the statutes are similar enough that when Johnson concluded that by basing an impairment rating on the 6th edition, it gave the trier of fact the ability to start with, or the doctor who provided the rating, to start with the 6th edition as a guideline and then use competent medical evidence. And if the 6th edition applies and it's appropriate, then go with that. But if there are other criteria or other things about the case that should be factored in, then the doctor and the judge in turn should be able to consider those things. And as long as the 6th edition is not a mandatory guideline that you have to follow with nothing more, then you don't have a constitutional problem. And I think the same analysis should apply to scheduled injuries. As long as the rating physician is using the 6th edition as a guideline and then uses that expert's own expertise to arrive at an opinion within a reasonable degree of medical certainty, then you've satisfied the criteria of the act and you've avoided a constitutional question. And where we depart in this particular case is that I believe the evidence as it went in satisfies that criteria.
Sorry, I just want to clarify. So you do agree that the doctor is not limited to the 6th edition?
I do.
But your contention is the doctors didn't limit themselves to the 6th?
Correct.
Okay.
In fact, Dr. Carabetta, and I disagree with counsel on this, Dr. Carabetta was given the opportunity to explain his rating and to expound upon how he would arrive at a rating if he did not solely consider the 6th edition. And he testified that he took other things into consideration, including the impact of the injury on the injured worker, and he rated the claimant with an 8 to 10% impairment of the right upper extremity.
But wasn't his reference 8% was to the 6th edition, 10% was to the 4th, and that was pretty much his primary reference, wasn't it?
It was, and he said variously when pressed that he'd probably say that the reasonable rating of impairment would be somewhere between 8 and 10%, depending upon which edition and which series of factors were taken into consideration. And so it is our position that the rating that the award was based on is within the range of the rating that was given by Dr. Terabata, and is probably appropriate and certainly satisfies the criteria of the Workers' Compensation Act if analyzed even under the Johnson case.
Counsel, I understand your position, but I'm looking at these comments by the administrative law judge, which really, it looks like the ALJ here said, we just have to look at 6th edition and that's it. I mean, use the 8% because that was from the 6th edition and kind of ignored some of this other evidence. Is there something in the record that I'm missing?
No, that is exactly correct. And I believe that from my experience with the judges and their viewpoints on determining impairment in body as a whole cases versus scheduled injuries, they have interpreted the scheduled injury statute to be one that does not include a requirement that you consider other competent medical evidence other than the 6th edition. Well, there is that other statute out there that defines functional impairment, and it requires competent medical evidence. Like counsel, I can't explain why a difference has been applied in scheduled injury cases, but from time immemorial, we have always presented our evidence, our medical evidence, and asked doctors to take into consideration all relevant factors, and we asked them to testify in terms of reasonable medical probability, and in doing so, to use competent medical evidence. It's just how we present our cases. And to not do so in a scheduled injury case and to only be limited by a guide that may or may not always take into consideration a particular case and its effect on an injured worker, I think leads us into constitutional problems.
So is there?
I think the judges have just interpreted it very narrowly in terms of how they approach scheduled injuries.
Sure, and developed a sort of pattern of practice with that. But should there be a concern, let's say that the doctors did consider all of the competent evidence, that the ALJ then says sort of repeatedly that he wasn't considering all of the competent evidence?
I'm not sure I understand the question.
Well, if your argument is that because you ask the doctors to evaluate all of the competent evidence, then the outcome is okay. I'm having trouble sort of squaring that with the fact that the judge disagrees with the analysis of using all of the competent evidence.
I think the judge arrived and the board arrived at the correct conclusion, maybe by using, even though the wrong analysis was used.
Okay.
And so my argument is because Dr. Terabata gave a range of 8 to 10% impairment, and the award was for 8%, we probably ended up with the right result, even if they refused to look at the statute using the Johnson criteria.
But how do we know that it was right if we don't have the benefit of competent medical evidence to support the 6th edition?
Well, my argument is that we did ask the doctors to address that, and certainly counsel for Mr. Weaver did in each case that each doctor testified, and asked the doctors to go beyond what was just required by the 6th edition and to give an opinion based on other competent medical evidence above and beyond the 6th edition. And each physician testified as to their opinion in that regard. Dr. Terabata's testimony was considered to be the most reliable, and that's how the judge ended up making his decision.
Counsel, if we are troubled by the administrative law judge which is rationale here, to the extent that we think that this needs to be reversed because it hasn't been considered in accordance with our reading of the statute and what we find is constitutional. In light of what you just said, is this something that can just be reconsidered on the record?
In my opinion, it can be because the testimony is there. And so if the judge is freed up, so to speak, to consider other evidence besides just focusing on 6th edition ratings, I think it can be done based on the record as it is.
You have 6 minutes, and I want to make sure that you can address your cross appeal. I'm not saying you need to address it now, but you have 6 minutes.
I will. Thank you. The cross appeal addresses the issue that is presented by KSA 44-501CE, which requires an award for permanent partial impairment to be reduced by the current dollar value of a claimant's pre-existing impairment. And in this case, Mr. Weaver was employed by the unified government for many years, and during the course of time, sustained multiple injuries that involved his fingers, his hand, his wrist, his forearm, and his arm, and received settlements for each of those injuries. It has been the unified government's position that because of that, 44-501 applies, and that statute provides a reduction in benefits payable to a claimant when they've had prior injuries and they've received a recovery for that. And just to paraphrase the statute a bit, the statute states that an award of compensation for permanent partial impairment shall be reduced by the amount of functional impairment determined to be pre-existing. And the percentage basis of a prior settlement shall conclusively establish the amount of functional impairment determined to be pre-existing. And if that pre-existing impairment was sustained while working for the employer, unified government, against whom the current benefits are being sought, any award shall be reduced by the current dollar value attributable to the pre-existing impairment. And so in presenting evidence, the evidence of the prior settlements was produced, and it was provided to the physicians, and both Drs. Carabetta and Dr. Popa considered that evidence. They looked at the guides in order to compute the overall impairment to the right upper extremity, and they both concluded that Mr. Weaver had a 30% pre-existing impairment of the right upper extremity. Based on the plain reading of 44-501E, his award, whatever amount is awarded, should be reduced by the current dollar value, and that the way to do that is delineated in the statute.
But didn't they testify that his 8 to 10%, let's say 8%, was above and beyond his pre-existing injury?
Correct.
So why would we reduce it?
Because the statute does not say that there should be an exception for that.
And if we agree with you, then that means that Mr. Weaver would get nothing for his hand injury, this current hand injury, correct?
That may be the result.
Why would that be fair or contemplated by the statutes that are meant to compensate him for giving up his tort right to sue about it?
Well, there must have been some type of thought about that when that statute was written. And there's not really a lot of legislative history other than the fact that there was a prior statute that was amended to presumably give more guidance about what to do when there's pre-existing functional impairment.
Well, it would make sense though. I mean, if the doctors had said he had 38% impairment, then it would make sense to reduce it by 30. But it just seems like they reduced it on the front end instead of the back end.
They reduced it in terms of only rating the current injury. That was the only rating they gave. Those other ratings were still out there. And using a plain reading of 501E, if someone has been compensated for injuries to, they're going to get an award for an injury to the right upper extremity, they've received prior compensation for a right upper extremity, then that should be deducted.
And that's my question is one of his prior injuries, for example, was to his elbow. And here we're talking about these two fingers and part of the wrist. Why does that make sense that since he had an elbow injury, he can't recover for his different injury?
Well, the whole statute leaves a lot of questions to be determined by this court. In the dissent that Judge Belden wrote to the board opinion, he proposed, although this is not written in the statute, but he proposed that we take the pre-existing impairment for everything that involves up to the level of the forearm. And I think that would have encompassed at least 3 of the prior injuries, and use that as the criteria to compute what that impairment is, and then use that to reduce the award.
Is it correct we don't have any appellate decisions determining the scope of or what our frame of reference is as far as it's a general upper right extremity or if it's the specific body part? We haven't decided.
Correct.
And work comp decisions, would you agree, have gone both ways at times?
They certainly have, and we're flailing around needing some guidance on this, obviously. There is an unpublished Court of Appeals decision. I believe it's the Willoughby decision. It doesn't address this issue head on, but it does say that you should interpret 44-501C as it's written. Otherwise, if you don't construe the statute to avoid, a different interpretation other than what it's written, then the legislature apparently enacted something that's meaningless. So to not, I can't imagine under what circumstance, if not this one, a 501C reduction would apply. And if it's not used here, then what is this statute about?
When you say as written, what specific language are you referring to?
It just basically says if there is pre-existing functional impairment and someone has been compensated for that, then here's the formula for reducing what they get in a later case. It
doesn't impairment presume that you're talking about impairment to the same body part?
I think that within reason, yes. And it's what we asked the doctors to do, was to take the relevant prior injuries and to use the AMA guides in order to combine that impairment to show what the pre-existing impairment to the right upper extremity was, since that is what we're dealing with, is a right upper extremity injury. Now, there are certain levels. In this case, it's a 200-week level forearm injury. So if you go with what Judge Belden said, anything that involves the forearm down should be fair game to use as a reduction.
Counsel, I'm going back to what Judge Hurst had asked about previously, and that is, it seems to me that if we say that there's a 30% pre-existing impairment here, but then the doctors testified that this was 8 to 10% beyond that. So aren't we talking about 38 to 40%? I just, my math brain isn't there seems to be an elephant in the room.
Yes, and that's another thing that Judge Belden proposed, is that, at the time that we were questioning the doctors, we did not know what the impairment was going to ultimately be decided upon in this case. But if they took into consideration the 8% and added it, and under the guise it turned into a 38% overall, then presumably the argument is that you would then reduce whatever that award would be by the current value of the pre-existing 30%. The statute just doesn't say that.
Does our record allow us to make that assessment at this level?
Yes, the doctors, at least Dr. Carabetta and Dr. Popa, were asked to assess overall impairment from prior and current. So that information is available as well.
I think that you are out of time, but I want to make sure Any other questions from the panel? All right,
Thank
would you like to take 30 seconds to wrap up or?
No, thank you.
All right, thank you. Council, you've reserved 7 minutes for rebuttal.
Now we're bringing paper up, so. Again, if it pleases the court, I'd like to start with just one last comment on the issue on the primary appeal. I think the panel grasps this conundrum that we would be at if you try to find a number now. Council indicates that Dr. Carabetta did this analysis. We haven't even talked about Dr. Popa, whose number is much higher because he did take into consideration competent medical evidence. But we can speculate about that all day. But what we do know for sure is that Judge Larson didn't do any of that assessment. He looked at the 6th edition, he rubber stamped it, he sent the decision out. That's why on the case, the primary issue on appeal needs to be remanded back for a factual determination based on the holding of the court. Now, the cross appeal, the appellee rests this on a misreading of KSA 44501E that states in part, an award of compensation for permanent partial impairment shall be reduced by the amount of functional impairment determined to be pre-existing. The question presented on the cross appeal is essentially the pre-existing functional impairment of what? The appellee claims that the answer is pre-existing functional impairment from a prior injury anywhere in the same general vicinity of the body, rather than an injury to the same specific body part. This is an implausible reading that finds no support in applicable case law, logic, nor the canons of statutory construction.
Council, how specific in your view does it have to be in order to be the same specific body part?
It's a very good question, Your Honor. And your questions earlier really hit right on the point. The intention of this credit statute is to not allow injured workers to double dip. If you have an injury and then you have that exact same injury, you don't get to collect for the same injury twice. Rotator cuff injury, Pardo. If the court looks at your holding in Pardo, you will see what happened there is Pardo had a prior injury to his shoulder. The testimony came in that even though it was the same rotator cuff, because the new injury was to the opposite end of the rotator cuff, that his impairment had increased by a number of percentage points. So the way credit would apply is Pardo does not get to collect for the first time he settled the rotator cuff, only the new. And your questions were so pointed. And I did ask Dr. Carabetta, and I did ask Dr. Popa to give an overall impairment rating. I asked them to assume, like case law says, if there's been a prior settlement, that percentage is established by law. No argument about that. It's 30%. So I said to Dr. Carabetta, if we take 30% before, which he has, what does he have as he stands here today? And Carabetta gave that number, and it's larger than 30. Dr. Popa did the same thing, and his number was significantly higher than the 30% that he gets. So how does it apply, you say? This court should issue an order, I would respectfully suggest, that says that the credit has to apply to the exact same body part to prevent double dipping. And it's really quite that simple, because when I say it's illogical how they're interpreting this, there is no answer in that statute if you don't wear a common sense hat to work that day. And under their logic, imagine this. Somebody has a hip injury, and then they have a subsequent injury to their big toe. They would never be compensated for that. Because, or as Judge Belden said in the dissent at the appeals board, if it's the whole arm, just start subtracting. It can't be the case. It just can't be the case. And in this particular situation, the appellant's injuries there were 4 of them. They were all to different parts of the body and distinct from those in the current case. If you look at the record, you will see that I had Mr. Weaver circle where the prior injuries were on an anatomical drawing of the human body, and there is no overlap. The Kansas Workers' Compensation Appeals Board correctly recently declined to allow a credit for prior impairments to the same upper extremity against subsequent injuries to the same upper extremity when the specific injuries and body parts are different. And we cited this. I'm referring to Judy Keenan versus the state of Kansas. And in that case, the appeals board wrote correctly, I believe, the new claim is for new and distinct body parts. That could very well be exactly how this court writes the order. The new claim is for new and distinct body parts for which compensation has not yet been awarded. Therefore, there is no functional impairment determined to be pre-existing as contemplated by KSA 44501E. For newly injured body parts, and credit does not apply. As I pointed out, that's exactly what's happened in this case right here. Mr. Weaver had 4 prior injuries to distinct and different body parts than those injured here, and all 3 doctors, all 3 who examined the appellant in this matter testified that he has sustained new and distinct functional impairment to different body parts because of this accident. Additionally, appellee's reading of the statute would violate the canon of construction that no reading of a statute should be adopted that would lead to absurd results. Appellee's argument that they should get credit for a prior unrelated elbow injury to Mr. Weaver's current thumb injury, that's absurd. A second canon of statutory construction that weighs heavily against the appellee's interpretation is the rule of constitutional avoidance. We talked about this on the primary appeal. If this statute were to be construed as appellee suggests, and I believe one of the panel members raised this very question, after they took credit for appellant's prior unrelated injuries, the award for benefits in the current case for new and distinct injuries would be reduced all the way down to 0. And just like this court did in the Pardo case, you would have to find that would violate the very premise of the Kansas Workers' Compensation Act, which is quid pro quo, wherein a worker trades his right to bring a tort suit for a predictable yet adequate remedy. No one, and this court has said it before, would say that 0 is an adequate remedy to trade that constitutional right for.
Council, we're out of time, but I want to make sure that my colleagues have the opportunity to ask questions.
Sure.
Are there any other questions? All right. If you'd like to take a few seconds to wrap up, go on ahead.
Well, I would just suggest to the court that this court enter an order declaring KSA 44510 DB 23, that it requires the consideration of competent medical evidence with the 6th edition only serving as a standard starting point, and remand the case back to further determination. And I would respectfully ask the court to reject the appellee's untenable reading of 44501E and enter an order declaring that pre-existing impairments can only be credited if it's to the exact same body part.
I'm sorry, do you agree that the record is sufficient for that remand to be decided on the current record?
It certainly is, Your Honor.
All right. Thank you, counsel. The court will take the matter under advisement. And we will endeavor to get a written opinion out just as soon as we're able.
Thank you.
At this time, the court will take a 5-minute recess, and then we'll go on ahead and hear the third case.
Yeah.
Flores.
Please be seated. We return from recess for the final case on this morning's docket. This is an appeal from Wyandotte County, case number 126025, in the interest of XL, a minor child. Will the parties please state their appearances?
Good morning. Mark Altenberg for DCF.
Thank you. This case has been assigned for 15 minutes each side, and the appellant may approach the podium and begin. Would you like to reserve any time for rebuttal?
4 minutes, if I could, Judge.
4 minutes are granted. And counsel, as I indicated at the beginning of today, if you'd take a minute to 90 seconds and just summarize the facts of the case so that we can have it for the record, I would appreciate it.
Certainly, Judge. For purposes of your request, probably the simplest way to describe this is who has the statutory authority to decide where a child in the custody of the Secretary for DCF is adopted to. Is it the Secretary or is it the District Court Judge? And may it please the Court. Again, Your Honors, good morning. My name is Mark Altenburnt, and along with my colleague Melanie Carroll, we represent the Kansas Department for Children and Families in this matter. At issue specifically is whether a district court possesses the statutory authority to overrule a decision made by the Secretary for DCF under KSA 38-2270A1 just 10 days after she made that decision for no other reason than the court having a disagreement with that decision. We submit that it does not. Now,
Counsel,
yes.
Before we get to that issue, I would like to discuss the question of our authority to hear this appeal.
Certainly, Judge.
And in particular, I would like to start with the Kansas Supreme Court's decision in Ray NAC.
Absolutely.
Now, that case is a post-termination motion for lack of reasonable efforts, similar to the motion that we had here. And our controlling court said that there wasn't jurisdiction for an appeal of that decision. Why is this case different?
Judge, the difference between this case and NAC, in NAC, they didn't deal with the issue of subject matter jurisdiction. The issue of the court overstepping its statutory authority was not at issue. In that case, they attempted to actually appeal the merits of the order that resulted from the lack of reasonable efforts findings. We are not appealing the merits. We're not claiming that the court made the wrong decision with respect to a lack of reasonable efforts finding. What we're appealing is the court's authority to consider that motion at all, given the Secretary's selection of an adopted placement just 10 days prior. That's the difference. So I
understand that. I'm looking at KSA 38-2273A, which our Kansas Supreme Court has told us that's what we look at. We don't look at 60-2102. We look at 2273, which lists 5 types of orders that are appealable. And I don't see this order as being something that is appealable under that statute.
Well, Judge, subject matter jurisdiction, which is what we brought this appeal under, is the power of the court to hear and decide a particular cause of action, or in this case, a particular motion. You don't need a statutory, you don't need a specific statute that says you can appeal this if it's a situation where the court has made a ruling on something it never even should have considered. That's why subject matter jurisdiction, if the appellate court...
But even in cases of subject matter jurisdiction, and this comes up in all kinds of cases that aren't related to child in need of care cases, but in cases of subject matter jurisdiction, there has to be some kind of procedural vehicle to get that issue to the court. So what is the procedural vehicle here that allows the appeal to go forward?
Judge, we submit that 38-2270A1 is the vehicle. It outlines the Secretary's authority to place a child that is in her custody for purposes of adoption. Furthermore, that statute specifically says the Secretary's consent is the only consent required for an adoption to take place.
In this case, she made that decision. She communicated that decision, and the judge specifically overruled that decision.
And I don't want to belabor this point, but that seems like the issue that you've raised, whether the district court had the authority, had the subject matter jurisdiction to consider this post-termination motion. What I'm wondering is, one step removed, what's the authority for us to consider and review that decision?
Judge, we would submit that your authority is found in years and years of Kansas jurisprudence, and we've cited the cases in our brief that give this court jurisdiction over subject matter jurisdiction issues really at any time. Subject matter jurisdiction is such an important issue, it can be raised for the first time on appeal. So it's not a statute that says X, but the history of Kansas jurisprudence says, and again, we've cited to it in the brief. The case of Kansas v. Dunn, which is a Kansas Supreme Court case, says very specifically, the existence of subject matter jurisdiction cannot be waived, and its non-existence may be challenged at any time. So,
let me just stop you there, because I mean, this is so important. It goes to our power to even consider this case at all. And so I'm looking at, let's say that this is a run-of-the-mill civil case, not these particular facts, and that there's a challenge to subject matter jurisdiction that's raised and ruled upon, but there's not a final decision in that case yet, right?
Fair.
So you can't just appeal the subject matter jurisdiction question. There has to be something to get the issue before us.
Well, Your Honor, the underlying judgment that has basically the court's ruling finding that there was a lack of reasonable efforts is that final judgment. What we're saying is the court didn't have the authority to enter that order because of 2270A1. If this court finds that because NRA NAC said these 5 orders are only these 5 orders are appealable on the merits, which is what NRA NAC stood for. NRA NAC didn't say anything about subject matter jurisdiction. It wasn't before the court. If this court finds that you can't appeal this kind of decision, then it has basically rendered 382270A1 superfluous. Because in that situation, the secretary can utilize her statutory authority. And statute is what gives subject matter jurisdiction. It doesn't just exist. If this court finds that this order cannot be appealed on the basis of the court basically usurping the role of the executive branch, then you may as well render that statute impossible to enforce, quite frankly, because that's what this would be.
Do you have a cite to any Kansas case which has an appellate case that has actually dealt with this type of issue, showing that it did take subject matter jurisdiction over it?
Well, Judge, there's actually 2 cases that have been cited to in the briefs where this issue, and it was back in 2003, the case of NRA JD is a case that we cite to where this specific fact pattern arose, where the secretary made a decision to adopt a child in her custody to a specific family. The other adoptive resource who didn't like that decision filed a motion for lack of reasonable efforts. The trial court took that up and, based upon a best interest analysis, reversed the secretary's decision. That case was appealed to the appellate court, and the appellate court heard it. The appellate court actually reversed the trial court's decision, saying that you cannot incorporate a best interest analysis into a lack of reasonable efforts analysis under 2264J because it's not there. So the inherent authority of this court
goes to the merits, right?
Well, it actually doesn't, Your Honor. And the reason I say it doesn't is because the court based its ruling not on whether or not there was a lack of reasonable efforts, but whether or not the trial court in that case, utilized the correct statutory standard. Because the statute, which is now embodied in KSA 382264J, says that very specifically, if the court finds that there has been a lack of reasonable efforts in progressing towards finality and placement, then it can make a finding of lack of reasonable efforts. It can rescind a prior order placing the child in the secretary's custody and then direct place the child. What happened in In re JD is the court said, the court read the statute similarly to what we're asking your honors to do with respect to 382270A1 and also 382264J. There's nothing in that statute that says a court can utilize its own best interest analysis as part of its lack of reasonable efforts. So in that case, it was not thrown back because of a lack of jurisdiction. In that case, the court said, look, we have a case where a court improperly interpreted a statute, and we can take that up.
Of course, and I'm going to ask this, and then I want to make sure that you have time to go to the merits of your appeal. But that case was a Court of Appeals decision from 2003. And In re NAC is a Kansas Supreme Court decision that's binding on this court from 2014. Right?
No, I agree with you, Judge. The In re NAC case, again, isn't binding on this court in this circumstance because it doesn't deal with the same issues. To take In re NAC and say that controls here when the basis for the appeal is completely different would be to put more into In re NAC, quite frankly, than what it is.
Thank you. Counsel, as I've indicated, I've taken up a lot of your time talking about this issue. I'd like you to have some time to get to the main issue in this appeal. And so I'm going to give you 6 minutes, and I'll add that to the other sides as well in terms of argument.
That's fine, Judge. I appreciate that. Thank you. I'm happy to be able to answer your questions. So while we don't want to, I understand your honors have read the briefs, you're well acquainted with the facts. There is a brief recitation of the facts that I believe is necessary to be able to get into the argument, because what we're arguing is very specific to the facts in this case. We have a child who has been identified as XPL, I believe it's XL in this case, was born on October 28, 2019. That child was immediately placed.
Be careful of
Oh, I know.
personal information.
We don't need the date.
You don't even need.
You don't need dates.
Okay,
Yeah.
fair enough. Was placed with the foster parent, had been there for 3 years at the time of this order being entered. In essence, on or about October 27 or 28, 2022, I'm sorry, 2021, 2022, we're currently in 23, sorry. The secretary communicated a decision through her workers to the parties, including the judge, that that she had selected based upon her review of the file, her discussing issues with a certain adoptive resource. An opposing adoptive resource filed a motion for lack of reasonable efforts approximately 10 days later, 10 or 11. That motion for lack of reasonable efforts does not actually contain anything that would be a lack of reasonable
But
effort.
we're not talking about.
We're not. But the reason I bring that up and the reason I will be bringing up the contents of the court's order is because we've submit that the contents of that order is evidence of the court's intent when it entered the order. And I'll get to that in a little bit. But that motion was filed. A motion to stay adoption proceedings was immediately granted by the court. And then we had the hearing. Secretary testified at the hearing. You've all seen the transcript. The court entered an order granting the motion for lack of reasonable efforts and directing the child to be placed with a different adoptive resource and than the one the secretary had selected. And that's where we are at this point. We file a notice of appeal and an immediate motion to stay. That motion to stay is denied. The court's basis for that is the order is not appealable. We would submit that's not the district court's job to determine, that's your job to determine. Long story short, our review of the statutes And case law, and at this point, your honors, you've heard it 2 times now with the 2 previous cases about statutory construction in Kansas.
Lucky us.
You're lucky you. It's exciting stuff, but I probably have to mention it anyway to get it on our record. Plain and unambiguous language needs to control. It needs to be given effect. And also statutes that can be reconciled without changing them need to be reconciled. Those are the basics of statutory construction in Kansas. We believe there's 2 primary statutes at issue in this case. I've mentioned them both briefly already. KSA 382270A1 and KSA 382264 subpart J. Let's talk briefly about what those are. 382270A1, well, 382270A sets out kind of the statutory framework with respect to what does a court have to do when it terminates parental rights. Okay, upon the termination of parental rights, it needs to enter one of 2 orders. It can't enter both, it has to enter one. Option A, well, A1, if we want to cite to the statute, is you place this child in the custody of the secretary for purposes of adoption. At that point, the statute is very clear. The secretary's consent to adoption is the only consent necessary. It's the only consent required.
So the secretary is acting in loco parentis in
Yes.
terms of her consent in this instance, but an adoption isn't final until there's an adoption decree by the court.
That is correct, but it's a different court. And see, that's the whole structure, the whole framework around this works together. And so you have that initial order placing the child in the custody of the secretary for her to basically grant the consent for the adoption. As Your Honor pointed out correctly, that doesn't end it. It just shifts it over to a different court.
So you're saying that court then that terminates no longer has jurisdiction for anything else after that?
No, that's an important point. And thank you for bringing that up because that was an issue that was in the briefs significantly as well. Once the court places the child in the custody of the secretary, the court's jurisdiction does not end, either personal or subject matter jurisdiction, but it changes. And NRA JD, actually both NRA JD and NRA DC, both cases we've cited to, state that it becomes supervisory at that point. And if you shift over, and this is where the next statute kind of comes into play, KSA 382264, that outlines all the requirements for permanency hearings. Okay, so the court has an obligation to make sure the parties aren't just sitting around. They're moving forward. They're making efforts to, number 1, find an adoptive placement. And number 2, once they've identified one, progress towards finalizing that aspect of it.
But that even if it is supervisory authority, it's not a rubber stamp authority, is it?
Well, to be perfectly frank, Judge, there's only one statute. There's only one statute that addresses how a court can take that authority back. Because if we revert back to 382270A2, that court had the opportunity at that point to place the child wherever the court wanted.
And so that brings us back to this motion for lack of reasonable efforts or reasonable progress. But my question, let me give you a situation.
Sure.
Let's say that there has been a determination by the secretary and consent given to place a child with a particular adoptive resource. And then it comes to light, perhaps through an interested party. This is certainly not the facts here, but it comes to light that that particular adoptive resource is dangerous.
Sure.
Are the court's hands tied?
Well, I wouldn't necessarily say the court's hands are tied, but there's a presumption. And I think you can read this into the statute that gives the secretary this authority. There's a presumption that the secretary is going to act in the best interest of this child.
Well, let's assume they don't. Let's assume that person's dangerous, all sorts of convictions for horrible, terrible things. You're saying that there's nothing that the court can do to stop that adoption because the secretary, in his or her wisdom, has picked that person, perhaps their cousin.
Well, I would argue that the statutory framework says that.
Because this would seem absurd. And we're not allowed to have statutes be absurd.
Well, I'm not sure necessarily that allowing an individual or a body or an agency to operate with the authority granted them by the legislature. I mean, that happens all the time. Obviously, police can go out and they can do their job. If they do something wrong, they can be sued. Now, it's not a
It
perfect.
can also be brought to court. I mean, they're
Correct. It's not a perfect analog. Now,
Would
in
it be
thi-
possible under those circumstances for there to be a motion for lack of reasonable efforts in light of the fact that the outcome is unreasonable?
well, I would argue that the statute isn't worded that way. What this court would need to do, and I hesitate to plan hypotheticals, especially when it is so far afield from this case.
But of course, you have to recognize that we're thinking about this case, but our rationale is going to be taken and used in the future as well.
That's correct. But I would also offer that Your Honor's role is to enforce statute. It's to enforce a statute that's clearly and unambiguously written. So I would say that, number one, the presumption, again, that the legislature is operating from is that the secretary wouldn't make that decision. And if they found out later that there was an issue, that decision would be changed. That's happened before in these cases. These cases take a long time. Sometimes the initial adoptive resource becomes a problem and they change. The first step in any of these processes is to try to reintegrate the child with the parents. That doesn't always work out. So the point is there an off-ramp? There are certainly judicial steps that could be taken by the parties.
the motion to stay, for example. Did the court have jurisdiction to hear the motion to stay?
My motion to stay? I'm sorry, DCF's motion to stay, is that what you're referring to?
Yes.
Yes, certainly did.
Okay, and then the motion to for efforts, it did not have jurisdiction for that motion.
Well, when the statutes are read, literally, and the answer is, it's not that the court loses its jurisdiction over reasonable efforts just because the secretary made a decision.
Okay.
They work together. Okay. 382264J says that the parties can't just sit around and do nothing just because the secretary made a decision. And when I say the secretary, I'm referring to, she doesn't make every decision. Her
In fact,
contractors do it.
this was the only decision
Right. Well,
she had made.
I'm not saying it's the only decision she's made, but this was a unique circumstance. There's no doubt about that.
Council, I want to, you have 4 minutes for rebuttal. I'd like to give you just a couple of seconds to wrap up, but we've gone way past your initial argument time. I want to give opposing counsel the opportunity to present.
Certainly. Thank you.
Thank you. Council, I'm going to give you 20 minutes for argument and be generous because we have been generous at this point.
The court's ready. Judge, I think your earlier questions really hit the heart of this appeal on the head. And my Latin teacher would be proud, but I think that can be summed up by the phrase quo warranto. It is Latin for what authority. And that is what the appellant has missed at every point in this turn. First, we have to start with what authority for this appeal. Then we have to consider what's the authority of the district court. And then I'd also suggest the court look at what authority in the record is there to support some of the allegations of fact that DCF presents in its appeal. And I think when we walk through these three pyramid down steps, the answer is very clear. This court doesn't have jurisdiction. The district court did have jurisdiction, and there's simply no merits to the arguments, which are sort of ironic because we can't get to the merits. I get confused by this. DCF concedes it has not taken an appeal with any sort of statutory authority to take it. There is no constitutional right to appeal. There is no general right to appeal. This is a statutory court. And without a statute permitting this court to appeal or a party to appeal to this court simply has no jurisdiction. That is a rule of appellate procedure since the beginning of time for this court.
Counsel, what about this argument that this is a question of subject matter jurisdiction? And we routinely take up subject matter jurisdiction even for the first time on appeal. Why isn't that a way to get us to this case?
Well, I think part of the issue is that DCF is confusing the standard of review and preservation standard for a subject matter jurisdiction claim with this court's actual authority to hear the claim. They've taken a direct appeal. You can only take a direct appeal. If there was a different case, if we were in a driver's license hearing or a criminal case, or even just a regular family law case where you have a right to appeal as a matter of statute, we can raise subject matter jurisdiction at any time. This case is special because this case is SYNC. SYNC is different. That is another hard and fast rule. SYNC is different. We have specific provisions controlling our authority and our authority to appeal, which is exactly what NAC says.
Why are they so limited? How does that make sense if you truly have an egregious situation that needs some type of review, where the secretary has clearly abused discretion or just made a ridiculous placement of a child in an adoptive home? How can it be the courts have no authority to review that, and that's just the way it's going to be?
Well, the district court has authority to review it. So it's not completely without authority, but this court to review that order, that does not exist. And it's the legislature's purview. They have specifically limited the ability to take this appeal. I
understand that on the idea of the merits, but we're talking about, so under this theory, district courts could act without jurisdiction, but because there isn't a mechanism for a review of the decision they've made without jurisdiction, that can never be attacked.
Judge, it can't be attacked through this procedural vehicle, but this court, the Supreme Court, and I must admit I'm a little fuzzy on this court's ability to hear mandamus and quo warranto orders. If there is truly a situation where a judge is issuing orders without jurisdiction, they won't reconsider them or pull them back in, then that would be the time for an extraordinary writ in an extraordinary circumstance, where a judge is acting willy-nilly, allowing the sex offender cousin to adopt people or whatever the case may be. There's just no way for a direct appeal, but there is still the ability for a supervisory court like the Court of Appeals. If I'm not mistaken, I believe the Supreme Court definitely has mandamus and quo warranto. And I think if you start at the district court level, this court can hear the quo warranto before through a civil appeal process, if I'm remembering the League of Women Voters cases right. So this just isn't the vehicle, is the problem. And they can't change their notice of appeal. They didn't file a petition for quo warranto, so we're not even in the right article of statutory authority to get to this court. And that's part of the problem here. It's just, you cannot square binding Supreme Court precedent with their common law subject matter jurisdiction argument, in part because DCF is just an interested party. And NAC is about an interested party. We can't treat interested parties differently. They're one category of party in a SYNC case. And so to say, well, DCF gets extra benefits because they're DCF or the secretary, but grandma who wasn't allowed to adopt, or a foster family that wasn't allowed to adopt, or a sibling that wasn't allowed to adopt, well, they just don't get that because they're not the agency. So we can't interpret it that way. Otherwise, we're going to create impermissible discrepancies in this court's precedent.
Counsel, I know that this case was not cited in the briefs, but I kept hearkening back to sentencing cases. And of course, we don't have the ability to review presumptive sentencing cases. But there is a line of cases under a case called State versus Warren. Are you aware of that case?
Yes, I'm aware of the exception where we can sneak a criminal sentencing appeal to this court.
No comment, but that case exists, and it says that if the district court has misconstrued its authority, then we can review that decision. How does that change our analysis, or is it applicable here?
It's not applicable here. So the criminal rights to review on direct appeal are enshrined in the Constitution. We have a right to meaningful appellate review as a matter of constitutional authority. Civil cases do not. And even when sync cases touch on civil or due process protective rights, that's the parents. The parents have a natural right to due process because that is their natural child. We are past that point. At this point in the proceeding, there is no one who has a right to this child, and no one should believe that they have a right to have this child. This is a child that currently has no natural parent or guardian entitled to due process. And until one is installed and those rights reattach, that's the difference between a criminal appeal and here. We have no due process issues here because no one has a fundamental liberty interest in this child. People who do, those rights were terminated.
Thank you.
So turning to the jurisdiction, the jurisdiction of the district court, that was established at the moment the child came into custody. At the order of temporary custody hearing, way back when, court established personal jurisdiction over this child, because that's what we're talking about. We're talking about the court's jurisdiction over a child. And by statute, the only time that terminates is one of three specific things, and none of those things have happened here today. To this date, this child has not been adopted. To this date, this child has not been subject to a permanent custodian, and she's not aged out. So until then, the court does maintain explicit jurisdiction over the child by operation of the sync code.
What about this argument that jurisdiction lessens, becomes supervisory, is only over certain things once the secretary picks an adoptive parent?
Well, there's two things with that. The first thing is that would have to completely ignore the section of 2264J that says if there's no reasonable efforts, the court can change its orders. So then we effectively go back to the moment of termination if the court makes that finding and the court enters a new order under 2270, which the court can choose DCF or it can choose a different resource.
So your position is that the reasonable efforts continues until one of the three items happens: age out, adoption, etc.
Correct, because if we have kids that don't have adoptive resources, we have to make sure they're getting what they need for their mental health while they're still in DCF custody, even though they're parental rights. We have to make sure that they're getting, they're going to high school. We have to check on their placement. We have to check on their, if they're in a QRTP, a qualified residential treatment program. There are many kids that end up subject to the court's jurisdiction without an adoptive resource, and we have to manage those kids' needs, and hold the agency's feet to the fire. Because otherwise, this kid is just thrown to the mercy of a system with no one to speak for them or make something happen for them.
The language of 64J says reasonable efforts or progress. And I know we're not getting to the merits of this case, but I keep thinking about, how does this motion address reasonable efforts or progress?
So this case is complex, and one of the oddities of this procedural history is that the resource the secretary selected that is the subject of this order and this motion also filed a motion for lack of reasonable efforts when appellees were originally selected at a best interest staffing for all 4 children, including XL and her 3 siblings. At that point, DCF didn't object to a hearing on lack of reasonable efforts, and the court's findings, which I believe are in the record, the first volume, were that we have delayed permanency all this time because we wanted to adopt all 4 of these kids together. We're not going to separate a sibling. And we're going to deny this motion for lack of reasonable efforts and direct placement because I don't think we've had a lack of reasonable efforts. I don't think the agency is acting contrary to the best interest of the child. And I believe that these siblings need to be adopted together. So then we fast forward to the secretary just changing her mind, which I would point out the secretary is a political appointee. I don't believe there's any evidence in the record that she has a psychology degree, is a social worker, has worked as a caseworker,
Nevertheless, has the authority.
but nevertheless has the authority. But I'm not sure that she certainly couldn't present expert testimony on a child's psychological welfare. But on limited information, she just made this decision, which was why the court was concerned, because she only heard one side of the story. And so when you only hear one side of the story, then without giving the other side an opportunity to respond, of course, we're going to have differences between what the actual facts are from each perspective. So
could you clarify one thing in the record for me?
Yes.
And that is when, so the secretary consents to this adoptive plan. Previously, had the department consented to an adoptive plan, or had the department just been moving toward that plan?
So that's the other interesting thing about the facts in this case, is that a written consent for adoption has to be that, it's in writing. And I believe this court can take judicial notice of the policies and procedures of DCF, and policy 5363 and policy 5301, among other policies, set out this very detailed checklist and things that have to be done before the written consent is actually issued. We have to have the best interest staffing, which was where both of these cases got to. Then they have to have a sibling split staffing, which is where the first decision was found to have more merit than the secretary's decision, because they did not do a sibling split. There has to be a file read by the adoptive resource. You have to the contractor has to prepare all of the adoption pleadings. They have to do an adoption placement agreement where the adoptive family reaches an agreement with DCF to have the child placed in their home for a certain amount of time before the adoption is finalized. And then there's a legal review by DCF's legal staff. And after all of that is done, the written consent will issue. We never got a written consent. DCF secretary never actually issued a written consent, which leads me to where's the facts? Because if their whole argument rests on the fact that this written consent was issued and it's not in your record, and I believe the evidence shows it did not happen, we can't even get to the factual event that they are basing their entire appeal on.
I want to clarify that because I'll say it's a little bit unclear. Is there not a written consent for either potential adoptive placement?
Currently, there's no written consent for this child. However, because the district court removed the child from DCF custody and took the child out of DCF custody, I believe the consent rests with the court, and that the adoptive parents' appellees have already been granted consent by the court.
But before that, there is not the secretary's consent for either of the placements.
Correct.
Okay.
And it just you mean the secretary's formal consent under these policies and procedures that
Right.
you just identified?
Well, it's the consent to adopt. The consent to adopt doesn't issue until after we get to the end of their policies and procedures. All that's happened at this stage in the proceeding is there's been a best interest staffing, and we have selected a resource to start down the road towards adoption.
But the statute referenced by DCF, in which once the secretary issues their consent, then the court doesn't have jurisdiction or something. Does that statute refer to the formal written consent?
I think it has to, Your Honor, because it's consent to adopt, and consent to adopt means something in the adoption code. And it's also consistent with other places that refer to adoption in the sync code. I mean, the jurisdiction doesn't end until the decree of adoption is entered, which from a policy perspective makes sense. What if secretary issues a consent and the adoptive resource gets hit by a bus? I mean, what are we going to do between the issuance of the consent and the adoption hearing in the adoption realm? The court still has to have jurisdiction. We have to have a handover. And the language in the statute is very clearly in the past tense. We are not going to lose jurisdiction over a child that the court terminated their only natural adult in their life, their rights. And we'll just give up. I mean, good luck. The DCF will take care of it. We have to have control until we know someone else is in control. It's the basic rules of parenting. You can't just leave the toddler and be like, well, I hope my husband gets home in 5 minutes. Surely it'll be fine. That's how we get to seek court half the time. So it's just their factual premise for their entire argument hasn't even occurred, is another part of the problem. It's not in the record. And I think the final, well, I'm sure I've got lots of scribbles, but one of the things the court also has to consider is that they have taken this appeal as to one specific child to essentially hint at a separation of powers argument, but they never brief it. But that's their argument, is that the DCF made a decision, the district court can't do anything. Well, that's not true. The court never ordered DCF to make a specific decision or select a specific resource. The court just looked at the statute, looked at the situation, heard evidence, assessed credibility, said, you are not making reasonable efforts, and I'm finding it's not in the best interest of the child, so that order that is in the best interest of the child is to place directly with the adoptive resource that the court selected. If we really want to fight about who has power over what, then do it in an extraordinary writ, where it's going to be DCF versus the court. We can talk about the court's authority. But instead, DCF has sought this action as to this specific child to try to continue to direct a specific result, which the district court made a finding after hearing evidence, and even evidence from the secretary was not in the court's, or was not in the child's best interest. So it's frustrating here because this is a child that needs permanency, and she is waiting on this appeal that is taken by an agency that was formally tasked with her best interests because they want to fight about who has power. That is a fundamental problem for me in this case.
When we talk about reasonable efforts and best interests, so I think there's some argument that once the secretary has found an adoptive resource or whatever, the best interest analysis has dropped out.
Judge, I don't think that's accurate, because there's other language in the code that talks about the best interest of the child is always paramount. Even in the adoption statute, when the adoption court considers an adoption, they have to consider the child's best interest. The best interest,
Of course, earlier in the case, when we're talking about a termination of parental rights and unfitness and continuing unfitness, best interest doesn't factor into that analysis.
It does. At termination, you have to find that they're unfit and that it's unlikely to change in the future, and that it would be in the child's best interest.
But I'm talking about the first two steps, like unfitness. That's something we just determined on facts.
Right.
So it's paramount, but there are instances where we separate out best interests from the issue that is front and center.
Right, but that's because those are the natural parents who have due process rights to their children. They have a liberty interest that we have to control and consider. So there's factors of unfitness, but you can have a finding of unfitness and still have a finding that's not in the best interest of the child to terminate. That's how we get to permanent custodianships. That's how we get to other permanent living situations. And sometimes that's how we get an extension on a reintegration plan, because it's not in the child's best interest and we're going to put more effort into the family to put them together. So the best interest of the child still controls. It's just that we have to weigh the interest with the natural parents who have fundamental liberty interests. We have no one with a fundamental liberty interest here.
So if we circle back to the statute in sync cases, it says you may appeal these orders, and it's 2273.
Mm-hmm.
Do you think the reason that it is so restrictive is to help achieve some permanency and stability for the child?
I do, because one of the things that has bothered me about these kinds of cases, and this is not the first situation I've been in with one of these, the kid needs everyone in their life. And when we have prolonged, really aggressive litigation, we damage those relationships. There is no reason in the world that a selected adoptive resource cannot go still see them on the weekends or say, hey, I can't make pickup. Can you grab the kid? There's no reason in the world that families who are all attached to this child cannot cooperate and work together. And that's what we want, because Lord knows after a kid's been through trauma and had their natural parents terminated, we want that kid to have everyone in their lives that loves them and can work with them. That's why having this ongoing litigation and these structured appeals, it just ruins those relationships. It makes everything more stressful. The kid is hung out in limbo. The parties are fighting against each other, which does not promote any sort of cohesive working together situation. NAC and NE, which is the September 2022 Supreme Court case that affirmed NAC, makes it clear that there were specific choices made about this statute. And this court just doesn't have jurisdiction. We don't want appeals. We want to get a kid to a home and have everyone in their lives they can. And long-term contested litigation does not facilitate that.
Thank you. Any other questions from the panel? Thank you, counsel. You have used all your time, but if you want to take 30 seconds and wrap up, go on ahead.
Judge, I think that it's very clear that this court needs to dismiss this appeal. The only other thing I want to point out is that the second page of the court's order subject to this appeal makes very clear lack of reasonable efforts findings that are based on DCF's failure to follow policy. And some of the cases that DCF cites, In re JD and I believe In re DC, specifically say you have to file policy if we're going to have reasonable efforts. So I don't want to get to the merits because this court can't. But even if we get to that level, it still doesn't work. As a legal argument, it still doesn't work. The court has no other questions. I just ask that you affirm the district court or dismiss the appeal.
Thank you, counsel. Let's have 4 minutes for rebuttal.
Thank you, Your Honors. And again, may it please the court. I think the situation that Your Honors are seeing here is a difference between practice and law. The Sink Court, it operates under the assumption, as counsel indicated, as if it has no oversight. And it does that because of this overarching ruling NAC that, quite frankly, doesn't say what counsel asserts that it says. In fact, I would submit to this court that there has been absolutely not one shred of law, either statutory or case law, put before Your Honors that makes this case not subject to your review. There's been a lot of biting around the edges. This case is not NAC. And if this court were to determine that this case isn't reviewable, then the secretary has no authority in reality. Now,
Can you step through something with me? And that is, there's this motion for lack of reasonable efforts that was filed in October or November of last year. And at the time that that motion was filed, would you agree that the court had jurisdiction to consider the motion until, in your view, we find out that the secretary had made a determination? At what point does the court lose jurisdiction?
Well, Judge, it's not about, and I want to be clear because this has been misconstrued. We are not asserting the court loses jurisdiction over this case. Court maintains jurisdiction over this case until adoption is final. What we are saying, there is no bright line rule as to how much time has to pass. We're dealing with the idea of what's reasonable. What is a reasonable amount of time for progress to be made towards getting to finalize an adoption? Now, a counsel indicated about the...
Counsel, I want you to answer my question, and that
Sure.
is, at what point, in your view, did the district court find out, or should the district court have found out, that it didn't have the power to consider this motion?
Well, Judge, the district court found out about the secretary's decision right around October 27 or 28. It was communicated to them. Only 10 days later did the other adoptive resource file this motion. And it's important, the timing is important because I understand that we keep talking about best interest and it's in the Sink Code. We actually have to read the statutes. And 33 and 20 and 38 2264J, it discusses reasonable efforts and the way that it talks about it, progress.
So is in your view, is it when the court got the motion that argued that reasonable efforts were not implemented in light of the secretary's decision? Was it the response that alerted the court to this issue?
Judge, quite frankly, once the court received this motion, knowing the secretary had just made this decision, the court should have said, I'm not going to consider this right now.
Because it lacks jurisdiction to consider it?
Well, yes, because it lacked jurisdiction to change the secretary's decision based upon that motion.
So is it that in your view, that the court lacked jurisdiction, or is it because the argument that was being made didn't correspond with reasonable efforts under the statute?
Well, the latter portion of your question, I mean, is factually correct. The motion had nothing to do with reasonable efforts. It didn't mention any. But the answer to your question is, once the secretary, and there's not a bright line answer, once the secretary has made her decision known, DCF and its contractor has to be given the opportunity to take all those steps to finalize.
So if the motion had been filed 3 months later,
Potentially.
so the court would have then had jurisdiction after 3 months, but not after 10 days.
The court always has supervisory jurisdiction. That's what the lack.
And the difference between supervisory jurisdiction and jurisdiction to decide the motion before it.
Well, the difference, Your Honor, is in who gets to choose and when does that choice kind of expire. Because you have 2270A1, and it says something very specific. It's not ambiguous. The secretary gets to make the choice. We've commented on the fact that there's no consent that's been filed. But
I think it doesn't say. Can you read specifically what it doesn't say? The secretary gets to make the choice and nobody else can ever make a choice, and that choice is the only one.
no, it says the secretary's consent is the only authority required.
Okay.
Right? But again, that doesn't change the court's role to make sure things are happening. And if nothing's happening, because we do want permanency, if the parties are not doing anything, they're not moving forward to achieving permanency with this adoptive resource, then a motion for reasonable efforts at some point becomes legitimate. And under 2264J, the court can then rescind its prior order under 2270A1 and then direct place. The problem we have in this circumstance is there wasn't enough time that went past for reasonable efforts to actually have taken place. If there's not enough time for reasonable efforts to take place, then there can't be a lack of them. And I think that is.
I'm just having so much trouble separating what you're discussing, which I view as the merits of the motion on lack of reasonable efforts, versus the court's authority to consider the motion that was filed, which is the subject matter jurisdiction question. Help me.
Your Honor, I don't think the court had the authority to consider it. What the court should have done, in my estimation, is the minute they received that motion, they should have communicated to the parties, I can't consider this. The secretary has made her decision under 2270A1, which is her statutory right to do. Now we're in the position where we're going to try to get this done.
And can you point me to the statute that says the district court couldn't consider that motion at that time, but might be able to consider a motion 3 months later?
Well, Judge, I think the language used in 2264J to define reasonable efforts is that language. If you read that statute and you understand what the term reasonable means, which as lawyers we all do, we've argued about it since law school. The answer is 2264J says if reasonable effort to progress have not been made towards permanency, then the court can make a finding of lack of reasonable efforts. Then the court can rescind its prior order. Then the court can direct place. It's that first step. Reasonable efforts could not have possibly not taken place here, regardless of what the allegations are.
Because you're measuring it only from the date the secretary voiced her decision or conveyed the decision and the 10 days after.
Well,
correct? That 10-day period?
Yes and no. And that's actually a good question, because this court had made reasonable effort findings 4 different times previous. Most recently, late August of 2022. That's why when we talk, that's why when council talks about how, well, we want to make this move fast and all of this just slows it down. At no point did the court have an issue with this taking 3 years in the first place. It was only that last 10 days that really triggered the lack of reasonable efforts.
Well, that was because they were trying to do a sibling placement.
Well, that was initially the plan, yes. But by the time they got to the end, and again, this goes to the merits, so I'm not going to go there, but that it had been 3 years, only family this kid had ever known. And there were disagreements within the agencies about what should happen with this individual child. Be that as it may, if we go back to that late August 2022 ruling on the lack of reasonable efforts, where the court found reasonable efforts. And if you look at the journal entry or the court's order, it says very specifically in a footnote, she only considered the period of time from that late August 2022 up until the time the motion was filed. So that's 3 months. 4 months, give or take. The only thing that happened in that period of time
Was a complete about face.
was the secretary exercising her statutory authority. That's it.
But reasonable efforts aren't measured just in time. I mean, council says that there's case law saying reasonable efforts mean you have to follow your policies and that kind of thing, right?
I would argue that neither of the cases she cited to say that reasonable efforts require following policy. There are exceptions in policy all the time. In fact, the secretary, whose testimony has been majorly misconstrued in this case so far, testified that policy gives exceptions to extreme cases. This she determined to be an extreme case simply because of the fact that this one child had never lived with the other siblings and had only lived with this one family for 3 years. That's the extreme nature of this. That is in policy.
Council, because we've had questions and this has been an interesting discussion, I've allowed this conversation to go on.
That's code for
Longer
Judge
than it
Warner
should.
loves jurisdiction.
That's
questions.
right.
We all love jurisdictional
Yes.
questions.
But at this point, I think unless there are other questions from the panel, I'd like you to take 30 seconds and wrap up.
I thank you, Judge. All I would say to your honors is on 2 points. Number one, there's nothing that says this court does not have subject matter jurisdiction over the facts of this case. This is not NRA NAC. This is not contained within the sync code. This is subject matter jurisdiction. And we submit this court always has authority to hear issues of statutory authority under any context. Number two, if this court affirms the decision below, it is in essence eliminating 2270A1 and 2264J, or at least rewriting them to build in some sort of caveat that the court may have if she doesn't like, or if it doesn't like the decision. That's with all respect, not your role. And we would ask that this court enforce and give effect to the plain and unambiguous language of those two statutes, reverse that decision and remand this matter.
Thank you very much. Thank you to all council. This has been a fascinating argument, and I understand that this is a heart-wrenching case, but the court will take the matter under advisement. This is an expedited appeal, so we will issue a decision as soon as we are able. And at this time, that concludes this morning's docket, and the court is adjourned. Thank you.